folks, thanks. We wanted to take care of some other items, so we actually went in and completed our 9 o'clock item before this. So we're waiting for Pat Cantor, our town council, to return before we start. So just give us a second.
Right at the beginning, label it up top, circle. It's a good try, right? Keep track of everything, right? Right. So much right.
Tag all set?
I'm all set.
Okay. You all set on you? Thank you. You all set? So the next item on the agenda is our 8:30 item, is deliberation for 540 Groton Road asphalt manufacturing facility. This includes site plan and special permits for major commercial and water resource protection district. For those of you in the audience, we are in deliberation, so the only input and discussion is really amongst the board or staff, or in this case council as well. If there are questions or need for clarification, they will be factual items only. Was it a 2 or a 4 or a 3 or 6? And we will ask the applicant or other parties for that information. That is the only input we take, and there will be no questions, no data from anyone. This is really just a deliberation before the board. So I actually want to start. Obviously, a tremendous amount of data that we have. In terms of any open questions, just data-related questions from the board, before we get into further discussion and deliberation, are there any? I had one, but that I'm going to ask the applicant. I believe Ross answered it for me, but Kevin, anything from you?
No question.
Okay. Andrew?
Nope.
Okay. Great. So, Chris, it's actually a question for you. On the plan, I just wanted to clarify the emergency easement and the proposed gravel haul road is one and the same, right? That will be the inter-site transport and the emergency access. Is that correct? Okay. Thank you. It was reflected differently on some of the plan pages, so I just wanted to make sure I was clear in that regard. Okay.
Labels that it was reflected differently, or?
Labeled on different sheets differently, but it's
okay.
Oh yeah,
okay, gravel road and emergency.
Yes, but I believe I found it correctly on the plan. So, from a procedural standpoint and an ordering standpoint, I believe the first item before us, and Pat's here, and she can direct me or correct me otherwise. First item before the board is site plan. We have updates and issues for consideration, comments from staff in terms of data and information provided. Are there any questions on any of the information within the site plan or other data that the board may have Kevin?
Real quick question, Ross.
Yes.
The alternatives that you listed out, if you want to explain that a little bit, and obviously if we deliberate as a board, depending on which alternative is discussed here, it's going to kind of, we're going to have to fill this in with
Correct.
with
Yeah,
items.
so procedurally, Pat, I don't know if you want to comment, Ross, I can't, so.
I think Michael answered it, and if there are any questions, I can certainly fill in.
Certainly the issue before the board is approval or other action, approval with conditions, approval or denial of the site plan. In any one of those cases, just as we have issues of consideration before us, sometimes shared by staff, sometimes provided by the board, those would be provided, amended to this, and then come back to the board for signature. If there are items for consideration, issues that the board has, comments that they want, we'd like to make them. We'd like them written into the record, and then the issues for consideration, and then ultimately signed by the board. So,
Thanks.
Pat, comments on that?
No, I think that covers it. I mean, I think in any event, you need to make findings that would support whichever outcome the board ultimately chooses for any of the decisions that you have to make.
I actually have one other question then related to that information, and Ross, you can clarify, or I'll ask the applicant. On page 4 of the issues for consideration of the site plan, there's a comment made, and we've discussed it a number of times in terms of material, aggregate within the site, off-site, and so forth, 50% and so forth. I do not recall, and if not, certainly be conditioned. What is the reporting metric or control mechanism for that?
For the interior, for
Quantity. How do we know it's not 70 or 30 or 60? I just don't recall seeing in the operations manual and that's fine. I mean, for my context, that's something that could be conditioned in terms of how that reporting is done.
I don't recall seeing anything submitted as it relates to.
You're talking about how do we make sure that at least 50% of the material is coming from on-site versus off-site?
Yeah, it's certainly been represented, and I don't expect it would be otherwise, but I don't know of control mechanisms that are in place to track that.
Right, and I don't have a condition of approval as it relates to that, so that would be something that the board would want to consider.
Okay.
And just on that, as a condition, you could have a reporting or monitoring requirement.
Yeah. Yeah.
That would
As it relates to the
if you granted, rely on the applicant to inform the board as to compliance with that. And then that's a condition.
So again, from a board perspective, as it relates to site plan, are there, if there are concerns on behalf of the board, we can certainly discuss those. If there are conditions that you feel could address those concerns, then we should bring them out and put them on the record and have them in this document. Or if there are not, then we can discuss that as well. So, but that's typically how we have done that, and we've made those edits here, and then it's come back to the board for signature. So. And there are certainly, so there's probably two things. When we look at site plan, we can get into it. I think we discussed at length some of the use classification, the type of use, the extent of use, and then there's a number of other criteria related to site plan. As you see written in the site plan conditions, pedestrian vehicular safety, minimizing cut and volume, obstruction of scenic views, visual intrusion, glare from headlights, lighting intrusion, et cetera, et cetera. So there are proposed conditions related, some of which we've discussed, obviously, fire, fire apparatus, equipment, so forth. So be happy to go through those kind of as written, or start in a general sense from the use and concerns that the board has. Because certainly we've had those questions and discussions in the past. So perhaps just open it up for discussion. So, there you go. Okay? Sure.
Well, thank you very much. I will start with talking with the site plan first. So the first thing, I'd just like to open up by saying a couple of remarks about this whole process, and then go right into what my concerns and my positions and things are. First thing, I want to acknowledge Mr. DeFelice. I mean, this has been a very difficult situation for him. In my opinion, you have tried to cooperate with us as best you can. I think you've handled yourself in a very professional manner, and I want to at least be able to extend that acknowledgement to you. I also want to acknowledge, although he's not here tonight, Mr. Deschaines, because he also had to, he was in the defense of this. He's did it both eloquently and courageously at times, so I wanted to acknowledge that I thought everybody acted professionally. I also want to acknowledge the opposition to the plan. Long process, at times the anxiety and the anxiousness about this thing created, but nobody really ever got out of control. Everybody deflected to the authority of the board, and I found that to be very, very inspiring, and I wish to thank you, and I think that you handled yourself well. So in total, this was probably one of the better experiences in town government I've had since I've been doing this, and I can tell you that it's certainly the most informative proceeding I've had since I've been on my 5 years on the board. So thank you all very much. As to the issues, I always thought the core issue here was our application of the bylaw. I think that became very apparent among everybody here at the end. And I think that always is and is the central issue that we need, that responsibility of the board is going to have to try to work out. And in particular, it goes to the definition of light manufacturing. And why it relates to the site plan is because as I read the bylaw, under section 10 of the site plan, I think it's section 9.4.4, section 10, before we can pass on a bylaw, we have to make sure that the plan is in compliance with all provisions of the zoning bylaw. And certainly the definition represents a portion of the bylaw that we need to be able to settle out. So in that regard, I'm going to restate my concerns about a couple of things. The wording of the bylaw, as I read it, imposes a very strict standard for the town with regard to what is allowed and what is not allowed. It states the conduct shall be something that may be detrimental to the health. That is a wide berth. And then it goes on and provides some very specific examples, sets them aside, if you will, to try to, and then determines them to be expressly prohibited. And they name special danger of fire explosion, pollution of waterways, corrosive or toxic fumes, gas, smoke, soot, etc. Now, we heard a lot of testimony in this matter, and as a result of the testimony, it was clearly undisputed by anybody that this plant will emit NO2, it will emit benzene, formaldehyde, and particulate matter. In defense of that situation, the applicant's attorney and representatives offered that the limits were below the EPA rates, the DEP rates. Dr. Green stated that, in her opinion, the substances were not going to present a hazard, and she likened the situation to I'll never forget, she likened the situation towards the risk of becoming an alcoholic from one drink. I think everybody remembers that. Mr. Deschaines made a very passionate plea last week that if we were to ban this particular project because of any emissions at all, we would be imposing a very strict standard, an unreasonable standard. And in response to those things, I would like to simply say this. My reading of the bylaw, and the way I look at it, and the way that I've heard people discuss it, is that with regard to the analogy of the taking one drink and becoming an alcoholic, I think the bylaw directs us to be teetotals. We're not supposed to take a risk. That's how I read the bylaw. Second of all, the other end of it was with regard to our imposition of a standard, an unreasonable standard. Although we may not reach the DEP standards and the EPA standards, the level of emissions is not inconsequential. For example, in the case of the NO2, the emission level for the NO2, although it may not exceed the current DEP standard or the EPA standard, comes very close to it, and that's a substantial admission, even though it may not violate it. In regards to the benzene and the formaldehyde, there is a risk. There was a risk stated. It wasn't as though the risk was some minimal amount, and I was left with the feeling as though that we were being asked to accept that risk. And again, I don't think that the bylaw allows us to do that. With regard to other emissions, there is not emissions, but other factors. There's a fire hazard presented by this plant. Although it may not be a dramatic or a high risk factor, it still is a special concern of fire. It's a petroleum fire. There is a remote potential for a levee, which is an oil explosion. And even though it's remote, it comes back to the bylaw. The bylaw, being very strictly interpreted, says we're not supposed to take that risk. And then there's a community impact. And although this does not have anything to do with the plan at all, it still, I think, requires the board to do some consideration. I was very surprised to find out that that section of town had a air quality issue. I had not known that before. Certainly, it was the emission levels that were being discussed drew the concern of the Department of Public Health. And finally, I think the other thing that really concerned me was the emission levels or the asthma levels at the school. And the question comes, and particularly bears on the special permit, as to whether or not this is really in the community interest, which is what the special permit governs. So with regard to the site plan, I would urge the board to reject the site plan for a very simple reason, and something that we're all aware of, it's not a surprise, and that is that because the definition or the actual operation as described by the applicant does not comport with the definition of light manufacturing, I don't think that this project has complied fully with the zoning bylaw, which is what the site plan review requires.
Dennis, thank you, Dennis. You raised a few issues: emissions, fire hazard, and so forth. There are proposed conditions, obviously, and review. Are there other suggested conditions outside of those provided by our consultant, Woodward, Kern, and RJA, that you would promote at this time?
Not at this time. I mean, there are certainly things that can be done, but I think the first thing we have to resolve is whether or not this thing is that issue about the light manufacturing. I think everybody in town knows it. I think we all know it. I think during the last arguments offered by Mr. Deschaines, he's certainly fully aware that that's the pivotal issue in this whole matter too. So.
Okay. Further comments?
Sure.
Andrew?
I'll follow up with Dennis. I would like to echo Dennis's general comments also. My thanks and appreciation to you, Rick, and to your entire team for all of the information that you have gathered for us, for all of the questions that you have gone back and gotten information and answers for. I truly appreciate it and appreciate all the hard work that you have put into it. I also appreciate all of the work that the Route 40 Coalition has done and all of the information that they have gathered for us also to consider. I think it would be a fair statement to say that nobody can say that we are not making this decision without being fully informed of everything that in some way is connected with this project and is out there. So I appreciate all of the hard work that everybody has done in this process and in this very long process. As Dennis said, I think for me the really key issue comes down to, is this a use that is allowed by our zoning does it qualify as light manufacturing? I certainly know, and I have read, that there's been a lot of discussion about just first the issue of manufacturing. I don't think anybody will disagree that this project manufactures, the final product is bituminous asphalt, okay? It's manufactured. That's the name of it, a manufacturing asphalt plant. But I don't think that's the end of the discussion and the question. Because then it is determined, is this use light manufacturing, is it industrial, or is it heavy manufacturing? And contrary to what may have been stated, I don't think that we leave common sense at the door when we're discussing planning and when we're even discussing legal issues. Okay? Common sense still comes into play. It has been certainly argued that because of the exceptions that are listed in our light manufacturing, in the definition of light manufacturing, that you can read from that, if it meets the if it falls within the exception, it is therefore heavy manufacturing and not light manufacturing. I disagree with that. Our bylaws have a definition for light manufacturing. They do not have a definition for heavy manufacturing. That omission, I do not believe, was accidental. I think that bylaws, when they were written, a decision was made that this town, with the exception of those industries, obviously, that were already existing in the 1955 when the bylaws were adopted, were grandfathered in. And with the exception of industrial uses that are specifically laid out in our use tables, such as quarrying, that other than those particular industries, a decision was made that we did not want heavy manufacturing in this town. And I think that we need to follow that decision as it's written in our bylaws until such time as ever our bylaws are amended to either add a definition of heavy manufacturing or add it to a particular zone in our town. And I don't believe that that's here today. So, for me, this plant does not qualify as light manufacturing. It's an industrial use. It's heavy manufacturing. I have a hot mix asphalt drum. I have a hot oil heater. I have oil and asphalt storage tanks. You can produce up to 400 tons of bituminous concrete in an hour. You can, I realize that your limit is 300,000 tons a year, and I certainly understand and appreciate you have to make that 300,000 tons last for the entire year, but that is still an industrial use. The truck traffic that is associated with this, I believe, has to be considered when you're looking at this entire project. Based on the information that the applicant provided to us, we're looking at 18 vehicle trips during a weekday AM peak hour, 14 vehicle trips during a weekday PRN peak hour, 36 vehicle trips during the weekday. That's on an average day. On a peak day, they go up significantly. I'm concerned about Route 40 being able to manage that traffic and to hold that traffic. I'm concerned about the increased truck traffic on Route 40. I am concerned about the safety that provides. I very early on raised the issue of whether these trucks would be going by, between 7 and 9 a.m. in the morning when kids would be out waiting for the bus. I think it's obvious that they may be on some days, maybe not every single day, but certainly some points that's going to happen. And I think that's a safety issue. I think it's a safety issue to Route 40 traffic in general when you have that increase in the amount of truck traffic. The emissions. My goodness, I've learned more about air quality and emissions than I ever expected to know in my life. I certainly understand and appreciate that the DEP has issued you an air quality permit and that you must comply with those air quality permits. As Dennis mentioned, we are very close to the levels on several of those issues. The PM recently as a month ago, I believe that standard was still changing and that the EPA is still issuing guidelines on how we're going to measure that. I think that has an impact upon the community, upon our air quality that is still that is unknowable right now because we just don't know what the EPA is going to do. It may turn out that it meets it. It may turn it out we don't because we don't know what the final standards are going to be. So, with all due respect and with acknowledgement and recognition of everything that you have tried to do to mitigate this project, to mitigate our concerns, to put in place a myriad of conditions, I am still stuck on the very basic issue that this is not like manufacturing. And so, because it is not like manufacturing, because it is not, or at least in my humble opinion, it doesn't meet the criteria for light manufacturing, I don't think it's an authorized use for this zone. And with all of the conditions that we can put on this project, I don't think we can condition it so that it would become light manufacturing.
Kevin or Fred? Kevin?
Sure. Again, I'd like to thank the applicant for coming to the table here. For years worth now, we've really taken it to you, I think, between our concerns, the coalition's concerns. I'd also like to thank the coalition. They've opened my eyes to a lot of different issues that I think this board needed to see. And I'd really like to thank staff because there's just been a tremendous amount of data here. A tremendous amount of sorting, a tremendous amount of organizing, trying to keep us on pace and moving forward. I think, going through all the different concerns we have with site plan, we've gone through traffic issues, we've gone through the air quality ad nauseum. I know that it's difficult to read all these numbers and come up with exactly what they mean. I think we've done a good job to try to compare it to other uses, what that would mean to the abutters. It's something that we have to be concerned about. I didn't find the air quality to be as bad as a lot of the reports that were being put out said. I think that if three different people are consultants saying three different things basically about air quality, two of which were pretty much the same. One was on the other side of the board, so it left a lot of us wondering what this really meant. I think the modeling was conservative, though. I think when we said, hey, we're going to model this, as if we were doing this 24 hours a day, 7 days a week. Obviously, that's impossible, but we were saying, hey, look, this is how we're modeling, and it's, the DEP granted the permit. So I think that, we really covered that as much as we really possibly could with the applicant. I didn't find it to be a showstopper. Regarding, jumping right into the use, everybody's reading this use definitions and trying to define all the different wording here as much as they can. And I think that, while a lot of this is subjective, I think a lot of the use that's happening out there is consistent with what's going on out there now, meaning, the coring, the work that's going on, rock crushing, things of this nature. So in my eyes, in my opinion, the light manufacturing characterization of this project, I wasn't concerned with. What I was concerned with was if light manufacturing isn't the use that would be covered for a asphalt plant, what use would be covered within our bylaw? And I don't think we have that. So my concern is, are we discriminating simply because we don't have a definition under our use bylaws that covers an asphalt plant? So in light of all the different things that are going on here, I really didn't have as much of an issue, I think, as Dennis and Andrea had with the use. Another concern I had is if we can't condition something to the extent that this is being conditioned on another project that's coming up. What are we going to, in other words, how are we going to, something's going to go in there. This is an industrial piece of property. How are we going to condition something, that may not fall under all the previews of special permit, site plan, everything else that we can do to, make sure that this thing is covered to its fullest extent, and that we have all the policing abilities onto this thing. So, I guess where I'm left right now, everything that the applicants brought to the table, I guess I'm kind of at the point where I'm prepared to support the applicant in this venture.
So one of the questions then, as you said, we may impose reasonable conditions. So to that extent, are there certainly a number of conditions here? Are there specific concerns that you would like to see additional considerations on?
I think you brought up a good point, Mike, in regards to the 50% materials.
Yep.
If we can ask the applicant, what is the process of getting the materials? Is it a purchase process that you're going to have with the abutting property? And will it be, receipts? Will it be something that we can track?
Not to interject. I think at this point we should ask for a condition that be documented regularly. If that is a concern of yours, not go into the details of that process, but specifically state that it be documented, regular, managed at the
I just wasn't sure how we could do it. But, that's definitely a point I agree with.
Yeah, and I think in some, it's certainly been represented. I don't want to create new information, right? So there is that provision of 50%. I think your question from a conditional standpoint is, can it be managed appropriately? And if it's not, then they're in violation of, if this is approved, then they're in violation of their site plan.
Right. I mean, there's a litany of different conditions here that any of which are not applied to, we can pull the special permit.
Right. So at this point, that particular one, you want additional regulation reporting.
I'd like to see, if there's, again, I just don't know how we go about doing it. Because that falls right into how many trips are going to be,
exactly.
Which is a valid concern.
Okay. Other concerns or questions, conditions that can address any other concerns that you have?
No, I think staff's done a really good job with listing out all of the conditions. I've been through all of them. I think we've covered each and every item in detail, and we've got the monitoring, air quality monitoring requirement. We've got the noise requirement. So while the abutters have a lot of concerns here, and I don't discount them at all, I think that each one of these concerns can be managed through the system that's been put in place here.
Okay. Thank you. Any further comments?
No, that's it.
Fred?
I have some general comments, but I also have three conditions I'd like to see added, and maybe a rewording of the fourth one.
Okay.
I don't know which order you would like. And actually, for the purpose that these, I don't know if they go in the site plan, site permit, or I had them in the major commercial.
Well, why don't you talk about any questions, concerns, then we'll get to specific conditions. So, yeah, why don't we do that?
Well, I'll just give you my general thoughts, and I too, like Dennis and everyone else, I would like to thank the applicant for all of the information they provided, the amount of data and studies we asked you to do, and it was very helpful in reaching our decision, helping me reach my decision. To me, there are 7 specific critical issues with this whole project. There's noise, odor, visibility, emissions, fire exposure, truck traffic, and then...
Slow down.
I'll be back.
All right.
And the bylaw definition of light manufacturing. Let me go through those very briefly. Noise, odor, and visibility. I am totally convinced that these are really non-issues. I don't think anybody going down Route 40 or the neighbors are going to hear, see, or smell this. And I base it on on walking through a competitor's facility last year, not the one in Portsmouth, this is the Dental one up in Drake, and also the what the applicant has proposed to put in there to further mediate odor. I think we'll even go further from that. Emissions. That is a very fluid issue. There's just too much data, I think, for any of us to fully understand. And being in a public hearing, listening to 6 PhDs spar back and forth, made my hair hurt. It was just unbelievable. But in the end, the applicant meets the current emission requirements. DEP has issued a permit and will continue to monitor the facility. And for these reasons, I feel the health risks will be adequately balanced and monitored. Fire exposure, I think the planned fire prevention and the fire protection are adequate for the risk that would be presented by this facility. Truck traffic. Obviously, there'll be a lot more trucks on Route 40. The studies today say there's 600 per day. This would add 100 to 150 further. That is a nuisance. But I mean, within any business, you're going to have more traffic. This is just going to be a little different. A showstopper for me was the nighttime travel. I just have a lot of empathy for people in Chelmsford, albeit there's only 17 homes, but I just could not envision on a warm summer night hearing those trucks going one right after another. But the applicant has pulled that back. So I'm down to the bylaw definition of light manufacturing, and this is where I'm hung up, because I remain unconvinced that a hot mix asphalt plant meets our bylaw definition of light manufacturing. Yes, it is processing and meets that part of it in the stretch, but if you drill down beyond that to the other parts of the definition, I don't think it meets that. And I don't know when town meeting approved this particular part of the light manufacturing, whether it was back in 1955 or not. But I have a hard time envisioning that they were thinking about a hot mix asphalt facility. I think they probably were thinking about a one-story assembly plant putting together widgets or something like that. And not something that was had 100 to 150 trucks coming in and out during a given day. In the end, I wish our board had dealt with this previously or early on, but I understand the reasons why we didn't. But, so at this point now, I've got a showstopper with the definition. And but I do think that we ought to go through these and make sure that we have the conditions that we want.
Yeah, you had some questions or concerns on the conditions, right?
Yes, I do. Can I go to the major commercial?
No, stay on site plan because we're not there.
Well, then I don't think any of these. They all deal with trucks.
Certainly, traffic. First item second item with respect to pedestrian and vehicular safety both on and off site. So.
But there's one item, one condition in the master commercial project I don't see. It may be in the site plan, but I'm not sure.
Okay.
It's the one that deals with the traffic, all the traffic going into Chelmsford, not coming back into Westford.
Page 4 of the site plan F, I think. I didn't see if it's the same wording carried over, Fred.
Yes. Okay, you're right.
Okay.
All right. My concern there is that I would hate to think that if this is approved, that trucks would be forced to go out towards Chelmsford and then drive 5 miles or whatever in order to go back down Route 40. I mean, it's ludicrous, particularly where the town would benefit by getting some hot mix asphalt, presumably would be used in Westford. So I think that somehow this condition has got to be reworded to allow for some trucks, the ones that are destined for Westford, or the ones that may be going west on Groton Road to Groton or something like that, would be allowed to make that right turn. That's what I'm saying there, because I just think that if we blindly follow that, I think it's just a bureaucratic blunder. I'd hate to see the trucks drive down Route 40 into North Chelmsford, back up to the driveway, turn around and go the other way.
A loop around on 3.
Yes, sir. Dennis, go ahead. Is there
Yeah,
clarification?
any clarification? I mean, you just made mention that the town was going to benefit by some use of the hot air asphalt. I haven't heard any of that conversation at all during this whole process, so I don't know what you mean by that.
There is a condition in here whereby the town would receive, what is it?
Per memo from the applicant, before
At
at
our last meeting.
our last meeting, before the closing of the public hearing, there were certain provisions. Nighttime operation, the odor, and
There is a
It is in
condition.
the site plan as well, it's number 7. It's at the very end, in which that is something in which one we would like to discuss a little bit more before.
And if I recall, we had comments on that actually at the last meeting, so
We
I
did.
know it was entered into the record, so.
11,
Sorry.
Do you want me to continue on with 3 other?
Yeah, please go ahead, because I want to come back to your
3 other
traffic
conditions.
one.
I think these have been discussed before. I don't think there's any surprises. But the applicant said that they would not use Jake brakes.
Yep.
And I think that ought to be noted in here.
Thank you.
Also, truck trailers must be covered, and I'd like to be fairly specific there. I think the trucks should be covered just after they're filled and before they leave the silo area.
It's part of actually the air quality permit from DEP, but I can add that in. Yeah, the air quality permit also lists that as one of the requirements about.
Very good.
But I think we
I don't
should
mind
have
calling
it.
it.
Oh, without a doubt.
I think we should call it out in here.
And the last thing, the trucks, the applicant stated the trucks would not be washed or maintained at this site. I think that should be a condition as well. And those are my comments on the conditions. Other than that, I'm happy with it.
Dennis, did you want to circle back on that other
Yeah.
question for clarification?
Yeah, I just have a question about, I found the provision, and I've heard it in fleeting passage before, but I've never seen it written down anywhere. But I have questions about the legality of that. I mean, first of all, there should be, if we want to go into, the applicant was filing for a major commercial development permit, in which case it's legitimate for us to be able to make some inquiry about what the benefit financially is to the town, or how much of a burden it's going to be. But I don't remember us ever having any conversations on that. And I think that's very significant, because I think we should check with town council. There's never been an assessment of the property, how the property was going to be assessed and discussed, if that were going to happen. And now we have a reference to a sort of a quid pro quo written into the law, that part of the benefit for putting this plan is to give materials to the town. I just have questions about that.
Pat, you want to comment?
Sure.
So,
I obviously haven't been through the year's worth of hearings and the evidence that all of you have been through, so I'm coming to it without the detailed knowledge that you all have acquired. But it is fairly typical for a major project for the applicant to offer some mitigation to the town. And in my opinion, if it has been offered by the applicant, it is something that would be within what is often included in major commercial, industrial, manufacturing types of developments in town for these as well. So I don't think that there is a legal issue, particularly since it's been offered by the applicant, and to the extent that, at least what I've heard this evening, there are concerns about traffic and other impacts. The town can use this asphalt for paving, for maintenance of the road that may be affected, that would go towards mitigation. That may not be factually what's proposed, so I may be speaking out of turn on that as a direct quid pro quo for the connection for the asphalt to the town. But in general, it's a fairly typical kind of condition, and I don't think there's really any legal problem with that.
Well, the question that arises for me is, okay, mitigation in the past has generally been the project goes in, and as a result of an external issue that arises off-site, the developer decides to provide some sort of construct a traffic system or something like that. What you're talking about here is you're talking about an extended period of time where this applicant is going to provide us with a certain amount of product, which is worth something. Now, is this going to be in lieu of his taxes, or is this going to be over and above his assessor's fees, or whatever? And I think that's something that needs to be concerned about.
It's stated as worded, or whatever the comment, you know.
I just think that's a bad precedent to go with.
Appreciate those comments. So we had discussion about certain impacts to the neighboring roadways given truck traffic.
Well, that I can understand, but
Yeah.
I mean, but a carte blanche contribution of asphalt to the town is something that I'm a little concerned about.
You're not going to pay that every year, so it'd be quite a road if you pay it every year. So Fred, any further comments?
No, I'm all set.
So, again, I appreciate everything everyone said, all the efforts on all parties, certainly the applicant. I've said it before and I'll say it again, so it's certainly been a long process. And again, when I look at site plan, look at the use, look at the use definition, and also look at the site plan criteria. I can certainly view it from a Webster standpoint in terms of processing, manufacturing, and so forth. But then when we get into, I'll call it the additional criteria, that further defines that processing or fabrication or assembly for noiseless and offensive, health, safety, welfare, danger of fire, explosion, pollution, right-of-ways, dust, fallout, or smoke, so forth. That's where it becomes challenging for me. And again, looking through the data, and if I look at site plan and look at the use, well, on the one hand, and this is a challenging site because this is an external light manufacturing. This is not a machine shop in a building. So if you look at the controls that have been proposed and are put in place, they certainly have some effect on this specific criteria. But in particular, I had concerns with some of the noise profiles, re-looking through some of the noise data. Great deal of data, and I appreciate the efforts in terms of looking at residential modeling. But again, from a noise source, nearest neighbors, which include commercial neighbors that are also impacted by this, that are actually, I believe, closer than the residential neighbors. Some of the assumptions on foliage attenuation and so forth, I think do not make this a substantially noiseless and inoffensive, even to some of the criteria that we have in our bylaws and so forth. I raised some concerns in terms of some of the materials, the asphalt, the recycled asphalt, and the ability to control that. It is in some context an uncontrolled substance. It comes in from various sources. There were various studies. I certainly appreciate Dr. Green's submission of some studies. There are other studies that, again, she referenced and I found that talk about potential impacts of that recycled asphalt. Again, part of the process that do prevent or do potentially have further exposure of chemicals and so forth that aren't dealt with in some of the emission studies. I looked at some of the traffic and safety. I think there were a few conditions that could be proposed out of Route 40. I think reasonable work was done on drainage, truck movement. It is a very tight entrance in terms of truck movements. There were some recommendations on widening and relocation along Route 40, berms and so forth. I think the applicant did had proposed some plans, striping and so forth to deal with that at the site entrance. There may be more that could have been done along those lines. There are still some concerns I have in terms of dust emissions, so forth, again, related to the additional criteria within the use definition, the PM 2.5, some of the road maintenance provisions that were in the, as was proposed by the applicant, I think presents some variability in terms of that number that, again, is fairly close to a limit. So given those, when we look at the type of use, when we look at it as this type of processing facility, that has to take into account, by our definition, these certain criteria. I think I too have a concern with this use as proposed and as defined. So, in looking through and that's why I had asked for some of the entrance roadway. I don't think there were a couple of recommendations from MDM for reporting, for truck log reporting that I don't see in the conditions. I think they asked for a monitor program with daily, monthly truck log. I don't recall program details. I'd like that at least reflected in the proposed conditions, because we had a number of questions on, i.e. the number of trucks and daily reporting. In MDM's memo from September 2nd, they recommended a monitor program, I'll give this to you, be developed and administered by the applicant with daily, monthly truck logs. I think it was agreed to, but I don't recall seeing a document.
In the conditions, 7 and 12.
Yeah, but it wasn't.
2.d.
What page?
7 and 12. If I get the right one.
Yeah, I think it just references MDM's.
Monthly monitoring program shall be developed and administered by the applicant with monthly reporting to the town to verify actual site traffic generation.
Yeah.
We can check to see if that's verbatim to MDM's, but it certainly captures the spirit of what they were.
Yeah, I think it is, but I wasn't sure of the reporting, the control mechanism for that in submission. I guess that is sufficient, so thank you. I think the strike modifications in there, turning movements, Groton Road. Okay. Again, I can't. I was trying to think of a provision along with. There were recommendations from MDM, and I don't believe it's just a question of fact. I don't believe there was additional widening proposed on Groton Road just at the site entrance. Correct?
It was not necessary, but the applicant would consider doing it down the road as mostly as beautification is what it really is. But it wasn't required in the auto turn analysis.
Okay. And I think in terms of the truck vehicle enforcement items, we talked about equipment, we talked about training.
Truck team, you mean?
Yeah. Is that sufficiently reflected in these conditions? Because it's, I think, on page 6. Because obviously that has an impact to the town. It's a benefit and an impact, right? It's equipment, personnel training, but it has a personal impact.
Yeah, that's
to
a
the town.
direct connection.
And it's great if the equipment is there. Does the town have the ability to use it?
Right.
So, does this condition 9 adequately reflect that? It's on page 6. Yeah.
It doesn't talk about training. If you're concerned about training, you need to be able to use it, but it doesn't talk about that.
Yeah, and I was trying to find the chief's memo.
It's in our packet.
Yeah, but there was a separate one in terms of, yeah, it wasn't, it was just follow up on the same thing. Or actually, he may have represented it when he was here. Certainly they are trained. He has trained staff now.
Right, correct.
Been borrowing equipment.
Yeah, he said he had.
So,
and it's largely a deterrent, just so that every operator coming out of that plant knows that they're responsible for their vehicle to be within the proper weights. But as I recall, there's scales in and out. I mean, you can't sell the product without scales, knowing how much you're giving them. So, I mean, but the truck team just keeps them honest.
And I don't, getting back to some of the noise data, which I had further reviewed, again, that it was stated in the report. It did not, obviously, it was the pressure in the plant that were taken into account. The exhaust fan pressure, not some of the on-site diesel trucks. I believe there was a number of diesel trucks as part of the operation, and certainly not the external truck traffic that are coming in and exiting the site. So, while that may not have pegged the noise number, I was concerned of modeling some of the nearest lot line and other uses within that proximity. So, and again, is that a substantially noiseless operation? So, given that, are there further comments? I think we've got some conditions proposed. Are there other conditions that have not been incorporated here or suggested?
I think we need to just close the loop on Fred's this discussion item of, do we want to in some way make an exception for trucks that may be headed to Westford and or Groton, as opposed to, we don't want them going into Chelmsford, backing into somebody's driveway or something, turning around and then heading back down to the 40. So I don't know that there's anything we can do about it, but I just thought we had to close the loop on
Okay.
We did have conversations, again, it was going back a while, so I'm stretching my memory, but we can work out a system within the plant where the operator is given a permission slip, so to speak. It comes right on his ticket, on his load ticket, based on a destination that would be predetermined by the board. If his destination or her destination was somewhere within Westford, because obviously developers and contractors and homeowners will use this product in town. It will become the most desirable place to purchase your materials. It'll be the best price for trucking purposes, if nothing else. So we could work something out where it says right on the ticket where they, at that point, they can take a right. And we had talked about this in detail, and I can go back into my notes in terms of wording a condition.
Also, with this same site, there was this concern was raised by the zoning board of appeals.
Yep.
And, it was also discussed, I believe there was a condition as it related to creating some type of ticketing system in which local traffic receive, red tickets. And that way, if they were pulled over, they could state that I have a red ticket.
So if the truck team it would be worked out with the truck team. So if the truck team knows.
But that would also be in the vehicle logs. That way, it would help the town to know how many local vehicle trips there were as well as.
What's the pleasure of the board? Obviously, exception versus the norm. We've got traffic data before us as part of the applicant and NGM study. Obviously, trucks entering. We talked about potentially coming from Westford in other directions. So, would we like to enter that on at this point? Dennis?
Well, it sounds like this is getting a little bit more complicated, and I just want to bring that out. I mean, first of all, from what I heard from you now, there's been a proposal in there for the truck team, which is going to require the purchase of a vehicle, the purchase of probably more than one officer to operate that team. The question is, where does the funding for the salary come from? Where does the funding for the vehicle come from? It may be a one-time purchase, or I don't know if the applicant is offering to foot the bill for this thing in perpetuity. So that's one question. So that cost may revert back to the town. Second of all, the situation involving the tickets. I mean, if you give out the red tickets, you're creating now you're creating a bureaucratic and administrative process that is going to have to be administered. Are we going to charge a fee for the ticket to deflect the revenue? Or are we just going to give it out as nothing? Who's going to keep track of it? These things are going to incur certain amounts of costs, and I think the overall effect is going to be just what the residents here really don't want, and that's profusion of traffic through their neighborhood. So I mean, that's part of the consideration. It may not bear down, it may not bear directly on the issue of the site plan and the definition, but now it's opened up a whole new can of worms.
So if I could comment too, I think the data before us, again, not, the data before us as represented by the police department was the equipment, which they currently borrow. They have, quote, some trained staff, but do they not, as their memo submitted, you know, there is not a specialized commercial vehicle inspection unit.
I don't think the chief was proposing to create one.
He is not.
Okay.
So the question then there is, there's easier access to equipment, which sometimes he has to borrow. There's an increase in traffic and a necessity to use those resources. Is there adequate ability to cover that and provide for vehicular safety? So
I guess I have my doubts.
okay, I think that's the data before us at this time, right? So, and Fred, I certainly appreciate your concerns. I'd be concerned at putting that in at this juncture, because this does have a data impact. I think it's all logical. Practical and logical, obviously, but the data may be variable, so it may not be able to be defined within an applicant report or an MDM study, right? It's one, it's two, it's...
I mean, what I don't think any of us want is a truck coming out of there, cutting through town to get onto 495 to head south.
Of course.
We don't want this to be a cut through. But if there's a resident in town that purchases a load, I mean, they ought to be able to get there.
Agreed.
I mean, I'm just thinking that at the end of that sentence where it says all traffic entering Cardinal are required to turn left towards Route 3, this would put it unless the ultimate destination is Westford or points west to Groton. That's right. I mean, so if we see trucks that are coming down through the center, getting on 495, I'll be the first one to blow the whistle on that, and I think many other people would be too. But if somebody in town wants a load of hot dog because they're redoing the driveway, how do they deal with that?
I understand. So, what's the pleasure of the board?
I agree with her. I have no problem putting in at the end of the sentence, unless you're a resident of Westford.
Destination is Westford.
Oh, your destination is Westford.
Or west of Groton.
I think the situation is you're going to have, it's not going to be the local homeowner throwing asphalt in the back of their SUV. It's going to be a commercial vehicle, so that's right. It's going to be regardless whether the guy's from or what. So
I think destination West is fine.
Destination of product is Westford.
Or points west to Groton. I mean, because some of the product is going out to Groton.
I think that would change the scope. Now it's, you know, Western would choose it. So let's deal with what we can with the data we have. I would suggest. So, Jonathan?
It's going to go. I still think that
I'm willing to limit it to unless the destination is Westford. I'm comfortable with that.
Yeah, I think without further consideration, I think that's all that I would be comfortable with.
Okay.
So. Kevin? Okay. All right. Thank you. Any further discussion?
one other consideration
Yeah.
on the fire and safety. I don't know. I glanced through this. I don't know if you addressed it. I know that, but I think it's important for us to have provision in here that if there's a malfunction or some incident or a shutdown at this plant, the fire department gets immediately notified about it.
Refer to our.
I would hope they would be.
Well, I mean,
well, they don't, but are emergency procedures
Yeah.
that have to be developed, and
I'd like to see it specified in there, so that if, there are other regulated industries, chemical industry, things like that, there are oversight agencies that watch that. Our oversight agency in this town would be the fire department. And for fire hazard, which is our principal concern, in consultation maybe with the Board of Health, that's fine too. But the bottom line is, if there's a malfunction or an incident, or something happens in that plant, there should be a notification process, and somebody should be able to come up and inspect it and to certify it's operating properly.
So the question is, Fred, I'll defer to you as the subject matter expert. We did talk about trip points, right? Temperature trip points, shut off, so forth. But that was a local, quote, local alarm, doesn't go out.
yeah, that may just shut the equipment down.
Yeah.
But what Dennis is talking about, if there's an incident there,
Yes.
And you do want the fire department notified, even if it's been put out. I mean, let's just say there's a small fire and it gets put out, you do want the fire department notified. But there is, Rob Jensen's procedures, I think they did call for generating emergency procedures.
Yes.
I don't have that in front of me.
If you look at the major commercial project, and I'm sure it's actually inside both the site plans, I have it. The major commercial project, page 8 of 12, you'll see at the top of the page, number 3 is Ralph Jensen's recommended conditions. Number B, it talks about that we need to develop and implement operating procedures, including emergencies. However,
But if you just address Dennis's concern, including emergency
Exactly.
notification
and notification of the Westford Fire
of the
Department.
Westford Fire Department,
Police Department.
and that will address that.
And I would word it including a schedule of emergency notifications. So there's a listing of types of conditions that they can work out together.
Okay.
What was that?
A schedule of emergency notifications will be developed and implemented. Notifications to the fire department.
Any other comments? Is there a motion as it relates to site plan?
I move that the planning board deny site plan to the 540 Groton Road project
Second.
for the construction of an asphalt manufacturing facility and related infrastructure as shown on the plan entitled Site Plan Asphalt Manufacturing Facility, 540 Groton Road, prepared by Landscape Consultants, dated April 6, 2009, revised through October 30th, 2009.
Second.
In accordance and reflective.
As reflected here by the discussion and deliberations by the planning board here tonight.
Second.
Okay. Comments or questions?
I'd recommend that you specifically find that it doesn't, I mean, if that is the majority of the board, which is what I'm hearing, that it does not, because it does not constitute light manufacturing, as that term is defined in the bylaw, and therefore it is not a permitted use in the, under the bylaw in the zoning district.
It's located underneath alternative one.
Okay, so let me start again. Okay.
You have a second.
I do have a second? I do. So why don't you withdraw your second, I'll start again.
I'll withdraw it.
You withdraw your
And I'll withdraw my motion and I'll start
Is
again.
there a motion on that?
Yes, there is. I move that the planning board deny the site plan application submitted by Newport Materials LLC and 540 Groton Road LLC for the construction of an asphalt manufacturing facility and related infrastructure as as shown on the plans entitled Site Plan Asphalt Manufacturing Facility, 540 Groton Road, Westford, Massachusetts, prepared by Land Tech Consultants, dated April 6, 2009, revised through October 30th, 2009. Because the planning board finds that the proposed use as an asphalt plant does not constitute light manufacturing and is accordingly not a permitted use in the zoning district. Any more?
For the reasons that.
For the reasons that have been discussed and deliberated here tonight.
Is there a second to that motion?
Second.
Is there any further discussion? Again, the motion is to deny the site plan. So a vote in the affirmative is to deny the site plan. So all those.
That's a majority.
That is majority. That is a majority vote on site plan. Thank you. So, any further discussion? All those in favor?
Aye.
Opposed? Abstain?
Aye.
One opposed. So, 4-1, the site plan is denied. So, I have a procedural question, Pat, then, related to the other special permits.
That's what's going to be my procedural question.
So,
That's surprise.
certainly we've touched on many of the topics reflected in the folks. If you wait a minute or
We're not
quiet
done.
or leave quietly, we have other business. So, as it relates to the special permit criteria, we certainly had discussions on as it relates to that this evening. You know, I'm trying to recall previous things we've done, but
We went through all.
you have, yeah. So,
I guess the question is, do we continue to vote on the special permits or not in light of the fact that it's denied site plan?
And the answer is, it really is up to the board.
I would then.
I can,
Okay.
yeah, I mean, I can elaborate on that, but there's
that was an answer.
not a right or a wrong way. The process, you can either call it quits or you can move on and make sure.
I would, as we've done before on other plans, render decisions on all applications before. So what's the pleasure of the board? Just
I would
Go
agree.
ahead. Yeah, go ahead.
okay. Then the issues with consideration on the major commercial project. Do that first. That should be before water resources. This one.
Yes.
Okay. Again, Fred, did you have a specific condition you wanted in special permit, not site plan, or was it just
Well,
back to you?
those, I offered 3 new ones.
Okay.
All dealing with truck traffic. I think they should probably be in the major commercial project as well.
Again, for the purposes of discussion, certainly my comments as it relates to noise, dust mitigation, and other items should be reflected both for special permit and site plan. I can recite those for the record, or ask that I can incorporate them into any decision. So, okay.
And I would say the same thing, that my comments should be incorporated into the major commercial project discussion and reasoning, and contribute to all the sites and all over there.
So, in particular, though, if you look at item 3, respect to landscaping and screening, I will make a separate comment. While I'm appreciative of the proposal by the applicant for berming related to the structure, there are other visual impacts that we do see many months of the year. I think there's a reliance on some local vegetation. It is a wet site around there, certainly from even the abutting commercial residences. The berming was done both for visual impact and for some noise impact. But I believe there would be some screening impact to the abutting residences. Site development standards, pedestrian vehicle traffic. Well, community character, certainly the applicant's representation of the EcoSorb, it's actually a typo on page 5, EcoSorb engineering manual. Again, I just want to make sure that there are items. Yeah. Okay. Any further discussion on this? Kathy, comments?
No, I think that we'll just go through and discuss the conditions.
Okay.
Okay, I move that the planning board deny the special permit for a major commercial project to Newport Materials LLC and 540 Groton Road LLC for the construction of an asphalt manufacturing facility and related infrastructure as shown on plans entitled Site Plan Asphalt Manufacturing Facility 540 Groton Road, prepared by Land Tech Consultants, dated April 6, 2009, revised through October 30th, 2009, for the reason that the proposed asphalt plant does not constitute light manufacturing, and is not a permitted use in the district, as well as the project's failure to comply with the standards of the commercial, of the major commercial development bylaw as discussed here tonight. Okay?
Is there a second?
Wait a minute, is that okay?
Yes,
Okay.
what I'm just thinking though is the conditions would be, if the board were to grant the permit, those were conditions that you would impose.
Correct.
So I think you need to address that, unless you're just not going to deal with the conditions at all. But what I heard before was go ahead, discuss the conditions, and vote on the conditions if you were to grant the permit. Was that?
You move to deny based upon that they have no standing for the
Right.
major commercial. That's what it should be, period.
Yeah.
Not on
Okay.
conditions. But
All right.
I think you have to make a decision as to whether or not you're going to vote simply just to say,
Okay.
basically on the jurisdictional issue, that because
All
it's
right.
not a use, you never get to the you never
Okay,
really get to
my
the
motion is
condition.
going to be to deny based on jurisdiction, to deny based on jurisdictional issue that this does not constitute light manufacturing and permitted use of the zone.
Second.
But, having said that, the conditions that I raised, they will go into this,
Commute point?
it's right, exactly. It's in the
But they were reflected in the site plan. So.
Well, no, because
There are no conditions associated. When you're
Correct.
looking at the site plan, right, it's just alternative 1 with the findings.
They should be
And then
reflected in the record, though, that, the conditions, they're going to be reflected in the record that said that after additional conditions to be added, had
Right.
this been approved,
Okay.
right?
right,
So
but
that-
there'd be no vote
Right.
on that because the board is it's either a two-step process
It's either in or out, and
right.
the only thing, it's out as a denial for the reasons as defined. And there are not specific site plan criteria or conditions.
Right. However, you could go on and say, notwithstanding the denial, if you were to grant, these are the conditions that you would impose, but you don't have to. That's what when the chairman asked before what you should do, and when I said it's up to the board, that's what I meant.
I think,
I think you should.
Dennis?
I think the wisest course of action is to stand on the original denial, rather than going to a convoluted reasoning to explain what we would have done if we had passed. I mean, I just think Ross's suggestion about standing on the fact that the plan does not comport with the bylaw and holding it that way is the basis for rejecting all of it.
I agree. Yeah, my motion stands.
There's a motion and a second, so, and I think there were certainly deliberations as part of the site plan. The question is, that is the finding as it relates to the special permit. And just a question, Pat. There were certainly criteria raised in the site plan, and will be reflected in the site plan, that do have, while they do have some bearing on major commercial project criteria, they would not be reflected in this decision because basically this would just be a carryover to the site plan. Is that correct?
Well, as I understand it, it's that they don't qualify for the special permit because it's not a use allowed by special permit in the district because it is not light manufacturing.
Correct.
So it goes back to the jurisdictional question. I think if you were to find that it did qualify as a major commercial project separate from the light manufacturing question, then you should address the criteria under major commercial.
I think that would probably confuse the issue.
Okay.
Certainly would.
All right. I'm confused.
Again, I want the board to be, there's a motion and a second. Let's discuss the motion. Is the board comfortable with that course of action? Are there questions, concerns related to that motion?
I guess I'm in the minority. I would kind of like to wrap everything up, and if there are conditions, even though there is the 600-pound gorilla here, which is a problem to many of us, I think it would be good to put everything down on the paper for whatever reason.
Well, I guess I don't want to get into what ifs. Obviously, this is part of the record, so to speak. And this is part of the material before us for deliberations. But if the intended course of action of the motion is approved to deny based on that, they will not be reflected in a filed decision. So.
Well, question then. Just a quick question while we're talking, maybe for if this were to go to court and we get overturned.
Don't go there.
All right.
Don't go there.
That's what the rule is all about.
I think Fred's comment stands, and I think I don't want to talk about precedent in terms of previous decisions that had different criteria that got us to this point. So.
Just clarification from Andrew on the motion. So based on jurisdiction, that application has no standing due to use not being considered light manufacturing.
Yes. That would be correct.
Okay, thank you.
And that was a second by Dennis.
So I think we should vote on the motion. If it fails, then we'll come up with another motion.
Okay. Any other comments? Staff, board? Okay. The motion was to deny.
The motion was to deny.
And this is a special permit?
Yes.
So it's 2 in the affirmative, 2 denied. So, all those in favor?
Aye.
Opposed?
Aye.
Okay. 4-1 to deny the special permit. The last item before us is a special permit for the Water Resource Protection District.
No.
Huh?
Stormwater management permit.
Water resources. Did I resource protection.
Yes, the Water Resource Protection District.
Okay.
The project is subject to a permit, but I'm not sure whether they applied for it at this point or whether they're gonna do that later.
No, I think that was, to be provisions,
That was referenced in here.
yep, that was a separate item. So, and that would come back to us as a separate item anyway, as we do with other applications. So again, last item before, the other special permit is a water resource, for tonight, is a water resource protection district special permit. Okay. Discussion on this, is there a motion?
Yeah, I move that we deny the water resource, the special permit for the Water Resource Protection District for an asphalt manufacturing facility to Newport Materials LLC and 540 Barton Road LLC, as shown in plans entitled Site Plan Asphalt Manufacturing Facility, 540 Garden Road, prepared by Land Tech Consultants, dated April 6, 2009, revised through April 30th, 2009, because the use proposed is not a permitted use within the jurisdiction.
Pat, any comment?
No, well, I do, actually, yes. The stormwater, maybe I'm missing something
Don't worry
here.
about
I
it,
thought,
it's a separate thing.
it's a separate
Yeah.
thing,
Yeah.
that's not.
That can come back at any time
Okay.
before the board, so,
Okay, all right.
yep.
Can we just,
Friendly amendment, yes.
yes, just to keep the language similar to the first, rather
yes.
than having it
Yeah.
backwards. And that language was based on jurisdiction, that application has no standing due to use not being considered like manufacturing.
That's fine.
Okay, thank you.
You're welcome. Yes, I can't remember what I said 20 minutes ago, so yes, make them all consistent.
There's a motion and a second. Any further discussion? Again, this is a special permit. The motion was to deny.
Can I
Kevin?
ask a procedural question? I don't have a copy of that, and I know it's kind of a moot point, but is it okay if I abstain from the vote? Is that going to make any, just because? Oh, wait a minute, I do have it. Apologies, I do have it.
Okay.
You even wrote on it.
You did?
Now you have to vote.
Now you have to vote because you found it.
Okay. Yeah, I did have this. My apologies. Go ahead, Mike.
There's a motion and a second. Again, the motion is to deny the special permit. Any further discussion? All those in favor? Aye. Opposed, abstained? Aye. 4-1 to deny the special permit. I think that's the last matter before us. Thank you all for, certainly the board, the applicant, residents. Appreciate everyone's time on this matter. So, is there a motion to adjourn?
So moved.
Is there a second? All those in favor? Aye. Aye.
Oh, no, sorry, it didn't work out for you.